And and again, it's a situation also where the parties have decided at the lower court to have this resolved on dispositive motions versus going through some sort of a trial where the parties would each present their witnesses. There'd be an opportunity for cross-examination where presumably there would be a true trial de novo. The overlay of a de novo review doesn't really make sense in the context of briefs that are being filed, and you have a court simply reviewing the record that's been transferred up to the lower court for review, and then resolving that case based on the dispositive motions that the parties have filed.
Given that this case was decided on paper, as you mentioned, and no additional evidence was presented to the Superior Court, I mean, do we essentially sit in the same position, the same seat as the Superior Court then?
Well, I think,
or are we reviewing to ask it more bluntly, are we reviewing the Superior Court or reviewing the Commission's decision?
I think you're reviewing the Superior Court's decision on appeal. I don't think that you're reaching all the way down to the Commission level to sort of see what the Commission did, but you're looking at what the Superior Court did to see if the determinations that it made were supported by substantial evidence in the case. And again, the other overlay to this is, this is a situation where the Commission is interpreting its own rules, and it's interpreting rules that were pursuant to its rate-making authority, and there should be, and this is borne out in the case law, there should have been some sort of deference afforded to the Commission's interpretation of those rules, and it's clear that didn't happen in this case. And why it's clear is because while you have a midden entry from the judge that, although it cites to an incorrect statute, it cites to 12-910E, which is the review statute that would apply if the Commission didn't already have its own review statute. It is a substantial evidence standard, but because the court also went further and simply adopted all of the arguments and authorities that the Sierra Club had cited to in this case, they were advocating for a de novo review. So it's either the court, it's unclear what standard of review that the court applied, or if there is some argument that the midden entry is the standard of review that they applied, they didn't apply it correctly, because clearly by adopting all their authorities and arguments, they did a de novo review as opposed to a substantial evidence review of this case. And the other thing that I would point out that also bears on the fact that the court came to the wrong conclusion is if you look at the judgment that the court issued in this case, it contains factual inaccuracies. It talks about the Commission's renewable energy standard and tariff rules do not allow MSW as an eligible renewable energy resource. But if you look at the provision in question, R142-1802A, there's 11 existing resources that are available to a utility. And within 2 of those, and I think this is in A1 and then down in, in A8, both of those resources already allow MSW as a fuel source for those technologies. So it's incorrect to say that these rules somehow don't already include MSW as an eligible renewable resource.
But assume that they don't. Just for argument's sake, assume that they don't. Does that resolve the matter, or did the Commission, is that why the Commission used belt and suspenders here approach and added the good cause?
Well, I think it actually goes more towards the pilot provision. The good causes and the waiver are another provision that was an alternative that the Commission said that this would qualify under, but it's important to remember that primarily the Commission found that this fell within the pilot provision, and the purpose of the pilot provision is for the consideration of additional technologies by the Commission. So it's somewhat of a red herring to go down this road of saying it wasn't included in the rules, because the purpose of the pilot provision is for the consideration of additional technologies. It doesn't say they have to be new technologies. What this simply means is that a utility, in complying with the renewable energy standard, instead of being able to go to one of those 11 available technologies which wouldn't really need any sort of approval to qualify for the renewable energy requirements, they would then have to proceed under a pilot provision and say, we would like to try out this new technology, here's what it is, and as long as it meets the requirements of the pilot provision, which we argue it does, then they would be able to consider it as a pilot. Now, I think at some point in time, if everybody lines up and wanted to include waste to energy as, one of the technologies that it uses in its resource portfolio, then there probably would come a time where the Commission would have to amend its rules to either to include it as one of the available technologies versus simply granting pilots to everybody, because that could be a circumstance where it would effectively usurp what the rule is.
Let me ask you to address a little bit the good cause and waiver, and to follow up on Judge Brown's question, if the A1 and A8 allowing MSW wasn't there, and if the pilot wasn't an option, the Commission here both went down the pilot road, as I read it, and the good cause and waiver road as well, to ask you to address that hypothetical situation.
Sure, and if you look at the provision, the waiver provision under R14.2-1816, A in particular, it says the Commission may waive compliance with any provision of this article for good cause. Now, I know one of the arguments that the Sierra Club raised is that Mojave hadn't somehow demonstrated that it wouldn't otherwise be able to qualify under the rules to seek a waiver, or that that somehow by use of the waiver provision you are in essence swallowing up the purpose of the rules, which I think there might be a disconnect between the Sierra Club and the Commission as to what the purpose of the rules are. I think the Sierra Club's advocating that these are some sort of environmental rules. If, again, looking at the Miller case, which agreed with the Commission, it indicates that the purpose of these rules is to require the diversification of the resource portfolios that the utilities, that the Commission regulates, so they diversify away from coal and natural gas. Now, as to the good cause, I think that goes directly to it. They have argued that, there's been no demonstration of good cause that would justify granting a waiver in this case. But I would argue again that this, if anything, demonstrates good cause, and that is, here you have Mojave Electric Cooperative filing this application to try out a new technology that would allow it to diversify its portfolio away from coal and away from natural gas with waste to energy. And it's important to note also that this waste to energy facility, unlike some of the other technologies that exist under the rules, is a baseload facility, meaning it could operate 24 hours, 7 days a week, whereas with solar or wind, you're relying on the sun shining or the wind blowing in order for the electricity to be produced. So I think, this, if anything, the granting of this waiver is a furtherance of the purpose of these rules. It's not somehow subverting the intent of those rules.
Counsel, maybe you could turn next to the trial court's ruling that there was no credible evidence to support the 90% determination. That, enlighten us on that a little bit. Where was the evidence substantial, and in what manner? Or, I mean, because the Sierra Club argues that it was 9-1, or that there was only one witness who testified or gave testimony that would even support the 90% threshold.
Sure, and I guess I would just say this. During the proceedings that took place at the Commission, there was parties that had varying positions. You had the Sierra Club, I think, initially saying that none of this should qualify, or at the very least it shouldn't be anything more than I think the 75% that the Commission staff had advocated for. You had the Mojave Electric Cooperative and Reclamation Power Group indicating that 100% of this could qualify, and that there is some argument, and other states allow this, that MSW in some states is 100% renewable. The Commission here took
no recycling
well
restriction, or
that I don't know. I think, and that's getting to that point, Your Honor. I think it's important here, and that's why I think the Commission came down the way it did. Is you had Mojave presenting 100%, you had Sierra Club relying primarily on a Cascadia study that took place, I think it was in 2003, And then you had Mojave, who actually had 2 witnesses that participated in a more current sample of MSW from the source where they were going to obtain the MSW. It acknowledged that there was some additional recycling that would be done at the outset. No one controverted that evidence at the commission. The Cascadia study, in fact, also notes, and again, this was in 2003, so at least from the commission's perspective, it was older information, but it also acknowledged that there was up to 20% of the MSW then that was recyclable. So it's not inconceivable to have 90% of this qualify with the evidence that was provided before the commission. And I know there was, it was an amendment that was issued, but that 90% certainly falls within the range of the percentages that the parties had advocated for in this case. And I think that there certainly is more than credible evidence that existed at the Superior Court level to justify the 90% level that the commission ultimately approved in the decision. And the only thing I guess I would add is, again, I wanted to reserve the remainder of my time unless you have further questions at this point.
Very well. Thank you, Counsel. Mr. Hogan.
Thank you, Your Honor. Tim Hogan, representing Appalachee Sierra Club Grand Canyon chapter. I think Judge Brown asked about strong disagreement about standard of review. I'm not so sure that's the case here at all, either on the deference issue or on the appropriate standard of review. We had argued in the trial court, of course, that under 40-254, there was de novo review, but the trial court judge clearly decided otherwise when he issued the minute entry and cited all of the substantial evidence cases.
Let me ask you, on whether he clearly identified the standard review. I've struggled with that. I've read the minute entry more than once, and what specific component of that causes you to say it was clear?
Well, Roman numeral 3, the delineation of the issue by the trial court says, was there substantial evidence to support the action of the agency, and was the action of the agency contrary to law, arbitrary and capricious, or an abuse of discretion? And in the previous, on the previous page, Your Honor, the trial court talks about the general standards for review, cites various cases. DeGroot will affirm the decision if it's supported by reasonable interpretation of the record. It's all very clear, not only from the delineation of the question, but from the cases that are cited, none of which have to do with de novo review. I mean, there's nothing in the minute entry that even discusses de novo review.
And I understand that, although none of those cite 254 either, at least if I remember correctly.
That's correct. Right. But it was what matters is what the judge's understanding was, and the judge's understanding was clearly that the appropriate standard of review was substantial evidence.
Mr. Hogan, does it strike you as a bit unusual, though? The court didn't cite a single, or in that litany or that list of cases, there's no Corporation Commission cases cited.
That's correct, but I'm not sure. I'm not here to explain the trial court's. Well, I'm here to explain the decision, but I'm not here to explain exactly how it was reached. But I don't think it matters. I just don't think it matters one bit. What the judge meant to do was to review the record and determine whether or not there was substantial evidence to support the agency's decision. The agency in this case happens to be the Corporation Commission, but the judge deals with a lot of agency decisions in administrative appeals, as you well know, and as I think this minute entry reveals. So, I mean, it's just absolutely clear, I think, that what happened here was a search of the record to determine whether there was substantial evidence to support the Commission's decision. On the matter of deference, I mean, there's a lot of discussion in the briefs about deference. We've never disagreed that the commission, or any agency for that matter, doesn't have to be the Corporation Commission, is entitled to deference when it's interpreting its own rules. There's a couple of situations where that isn't applicable, though. One is where the commission has used the rules in a way to achieve a desired result, where it was very clear from the beginning of this proceeding that that was the result that was going to be achieved come hell or high water, that they were going to get there and they were going to twist these rules to whatever fashion they needed to in order to achieve that result. You're not entitled to deference when you've abused the deference. And this entire record demonstrates that abuse. The second point about deference is there's no issue of deference when the rules are clear. When there's no ambiguity, the commission asserts there's ambiguity. Well, they have to, because then deference becomes applicable. But if there is no ambiguity here on either the pilot rule or on the good cause rule, the waiver rule, then we just, deference is off the table. It's not an issue that needs to be considered. So whether these were rate-making rules or pursuant to the commission's constitutional grant of authority to establish just and reasonable rates, just doesn't make a difference in this context. Were those elements not present here, ordinarily the agency is entitled to deference interpreting its own rules. Here, though, the pilot rule is very clear. And you don't even have to resort to the history here, but the history of the development of this rule is another example of why deference shouldn't be accorded, where municipal solid waste was specifically excluded by the commission. There's a lot of discussion about whether the commission knew about this because it was the subject of a staff proposal originally. But if you look at the decision approving the rules, the commission talks about the exclusion, all the comments it had received. This was a very controversial issue at the time about the exclusion of municipal solid waste. And we're not talking about we're not talking about the biogas rule, which garbage produces gas, and you burn the gas and you can produce electricity. We're talking about burning the garbage itself, which is a far different exercise and was the subject of much discussion at the commission at the time the rest rules were enacted, and the subject of many, many comments by the parties to that proceeding, and the commission chose to leave it out at that time. That was in 2006. And so, just a few years later, we see an application to allow a pilot program or a waiver for burning garbage. Well, to be perfectly candid about the pilot program, it's not as if a pilot is necessary when this technology has been known for years and years. That's why we have so much data about the operations of these facilities, not only domestically, but across the world. There are a number of waste-to-energy facilities in the United States and internationally that I'll get to in a minute about the substantial evidence in this case. And so we know that's a given commodity. We know what these are. We know what they do. We know what they emit. And we know to a fairly certain degree how much of the electricity can come from biogenic sources out of the garbage that is incinerated. So there's that background here. And the commission staff itself rejected application or using a pilot program for this application. The commission staff read the rule, which is, again, why deference isn't accorded in this particular situation. Read the rule where it says it doesn't include fossil fuels. Well, municipal solid waste includes fossil fuels. There's just no question about that. And that it can't be and that it can't be a product that uses non-renewable fuels. That's clear that the pilot program is not intended and was not designed and does not, by its language, permit a technology that relies on fossil fuels in whole or in part to produce energy. And there's just no question in this case that municipal solid waste does. Let me talk about the waiver provision for a second. The staff, as I said, rejected the application of a pilot using the pilot program here and instead said there was good cause for a waiver. The waiver rule itself, 1816, talks about waiver with compliance of the rules provisions. Well, I mean, I'm still at a loss to understand how we're talking about waiver of compliance when if what the commission has done is allowed, there would be no compliance issue. They'd be in compliance. The compliance part of this was clearly designed to for a utility to be able to say, well, we can't secure the appropriate amount of renewable energy from the sources and therefore request a waiver for this particular year or for some succeeding year. That we can't do it because it's not available on the market or the price is too high or whatever the reason might be, that it would constitute a burden on our ratepayers. That's the reason for waiver of compliance. The Commission has interpreted the good cause to mean basically whatever it wants. And specifically in this case, determination, well, the benefits of this exceed the disadvantages somehow, and therefore that justifies a waiver. Presumably that's underlying every Commission decision, that the benefits of something exceed the disadvantages. That's not a principled basis for a waiver. That's no basis at all. It is simply a fallback catch-all provision when the Commission determined, or the staff at least, made the recommendation that the pilot wasn't the appropriate way to go.
Is there any legislative history on that good cause exception, how it came to being, or any comments made that are similar to the pilot program? You talked about those comments, but what about this good cause exception?
Not to my knowledge, Your Honor. Finally, let me talk about substantial evidence here. First of all, I think I heard that the Sierra Club was putting its eggs in this Cascadia study basket. That's just not the case here. Let me paint the picture for you a bit. The staff went and examined all of the data nationally and internationally from 3 different sources about what the appropriate range would be for the percentage of electricity that could come from biogenic sources when you burn garbage. And those are cited in the staff report. They're cited in our brief. Those percentages fell in the 60 to 75% range for all 3 sources. Actually, one was lower than that. One was 40 to 70%. So that's the staff's, and of course, the staff recommended the 75%, and I'll get to the reason why they did that in a moment. But that's the staff witness, and the report she prepared and it was based on actual operating data, not guesstimates, not some guy sitting down in a room full of garbage. This was actual plants, waste energy plants in the United States and internationally, 60 to 75%. Then we had the applicant, his expert, or the company's expert witness, professor from Columbia. He testified that his team had actually evaluated the stack emissions from waste out of the smokestack. Had actually evaluated stack emissions for waste to energy facilities and determined that the amount that could be of electricity attributable to biogenic sources would be about 65%, within the range that staff had identified based on a larger database of domestic and international sources. The Sierra Club had an expert witness. That expert witness testified that the range, again, would be for determining how much could be produced from biogenic sources, would be 40 to 50%. Lower, to be sure, but not out of line with some of the data that staff had examined with regard to the various national and international labs that study these things. So that's, we haven't even gotten to talking about Cascadia first yet. This is the evidence that the experts talked about at the hearing in this case. These weren't, these were qualified experts who deal in this subject matter area all the time. Then we had the guy who wants to build the plant, who's never built one, never operated one, but he decided he would figure this out. He had to do a air permit, so he contracted with a private hauler to get 2 truckloads of garbage from the Glendale area, turned out to be Avondale, which is where this plant would be located, out towards Surprise, actually. He didn't get 2 truckloads, he got 1, and he and 8 to 10 other people sifted through this garbage for 2 days and couldn't get the job done. It's like 15,000 pounds or something like that. Sifted through the garbage for 2 days, still didn't get it done, testified that the garbage all neatly went into various categories, the paper, cardboard, metals, and that there was no residue left. What one of the witnesses called the gooey mess that we all associate with garbage. Although one of the guys that he sat down with and did this testified that there was a gooey mess, but the principal who wants to build this plant said no, it all neatly sorted into these categories, and then once they did that and they weighed it to figure out what percentage each constituted out of the total amount, once they did that, they sat around and decided, well, we can get more recyclable material out of this garbage. And maybe they can. They applied recycling rates as high as 85% to some of the categories of garbage here to decide that. And by the way, after just sifting through the garbage, they had 82% biogenic material. And by the time they were done applying recycling rates, they came out of thin air. They have no basis in fact, other than the fact that he and his buddies sitting around a table decided those were the recycling rates that they would apply. That took the biogenic material from 82% to 95%. More than anybody else in the world has ever done, somehow. Just him and his associates figuring this out. They've somehow, figured out the theory of everything or whatever here, and been able to achieve what nobody else could. And so you take the 95% biogenic material, you apply heat rates to it because garbage doesn't burn at the same heat rate, doesn't have the same calorie value, which brings it down to 91%. And that's where the commission got its 90%. This was all about, and by the way, when the staff's recommendation about 60 to 75% was made to the commission, the company objected to that and said, well, we can't build the plant, can't make it economically viable if it's not 90%. Well, and lo and behold, that's what the commission decides to do. I think the trial court judge was being charitable, saying there was no credible evidence to support the commission's factual determination in this case. There just wasn't any. And by the way, you can see where staff itself was being generous to the company because it had a range based on its examination of all the data of 60 to 75%. It picked the high end of the range. It knew these numbers were out of whack and said, well, we're at least going to give a nod to the fact that these guys have come up with something nobody else has done and pick the high end of the range that we've identified here. I mean, just, it's not just lacking credibility, it's totally incredible. Thank you.
Thank you, Mr. Miller. Mr. Van Cleve, rebuttal.
Thank you. I only have a little bit of time left, so just sort of two main points that I would like to make. And I think this was already pointed out with some of the questioning is if you look at that minute entry that the court issued, it is completely devoid of any recognition of the commission's constitutional origins or any of its constitutional authority, looking at the Woods case, looking at the Miller case that actually said that the rest rules fall within the commission's rate-making authority. There's actually no indication that the lower court actually understood that the commission was even a constitutionally created agency, which I think sets it apart from what may otherwise be a legislative agency or an executive agency. The other thing that I would like to point out is this notion of what the commission did here, and I think this case presented a very unique opportunity for the commission because what it did, it has allowed the commission through the use of what essentially is an experiment to have a utility utilize what is mostly a biogenic baseload resource. And I say mostly because in this case, all of the parties were in agreement that some portion of the MSW is biogenic and would be considered renewable. And with that,
Counsel, what about Mr. Hogan's comments about the good cause exception? Does it apply to more than just a waiver of compliance? I mean, if so, I mean, how broad is it? It's so broad that you could just do anything?
well,
That anybody could apply for anything, that they don't have to comply with the rest rules at all?
you have to remember what the compliance is in this case. Compliance is what a utility has to achieve as far as renewable energy credits, which means is the percentage of its resources that come from a renewable source. So in this case, that is exactly what was done here. It was compliance allowing them to have a portion of the output from a waste-to-energy facility, a discrete waste-to-energy facility, to qualify for renewable energy credits. Not 100% of it, but only a percentage
So
of
why
it.
not set the threshold at 75% and say, if you need to seek a waiver from the 75 to 85 or 85 to 90, then you can come back to us and seek a waiver for that portion?
Well, and I think you're talking about the 90% that was
Yes,
approved by the
yes.
commission. I think that what that gets to, though, is, again, contrary to what the Sierra Club has said in this case, what is unique about what the company did here that wasn't provided, to the best of my recollection, by any of the other parties, including the commission staff, was what does additional recycling do to that percentage? the plants and the stuff that was cited to by staff and by the Sierra Club all talked about what percentage of output would come from biogenic sources, but there was nothing provided by them to dispute what Mojave and RPG put forth as far as what additional recycling they could do. I know they take issue with it, or they took issue with it and continue to, but they didn't provide any sort of contrary evidence at the commission to dispute that those numbers were too high or shouldn't be used by the commission in coming up with what it did. And I guess I would just close, unless you have other questions. What the commission is seeking here is that you vacate the lower court's decision and affirm decision 73252. Thank you.
Counsel, thank you. Thank you for your oral presentation today. Thank you also for your briefs. They've been very helpful to us. We will take this matter under advisement. We'll issue a ruling in due course. We stand adjourned.